I welcome all of you to the second session of the day. The resource person for this session is Shri S.R. Somasekhara sir. Sir has practiced as an advocate from 1979 to 1985 and joined the judiciary in the year 1985 as a Munsif, and after serving in different places and cadres, he retired as a principal district judge, Bengaluru Rural District. After retirement, he served as a resource person in Karnataka Judicial Academy and participates in several training programs and workshops organized by Legal Services Authority, bar councils, and bar associations. He has also been a part of a number of programs for candidates taking up district and civil judges examinations. He has judged several moot court competitions on number of occasions and addressed students as a guest speaker in several law colleges. Sir is also an arbitrator on the panel of arbitrators of High Court of Karnataka and has done number of private arbitrations. I humbly request you now to please address the gathering.
Good afternoon, friends. And we ate by 30 minutes, came quite early. So they just offered me coffee, and the person who had to drink coffee, he said that the hotel was a little away. When I told that Subramanian will start, he said it's all good, it doesn't matter. You don't have any session after this. So first of all, I thank Dr. T.R. Subramanian for giving me a second opportunity to come here. About 5 or 6 months back, I had come here for the first time to speak about the same subject to the students. It was then still Indian Defence Act of 1872. Now from 1/7/2024, we have Bharatiya Sakshya Adhiniyam 2023. There's one fundamental difference between my contemporaries and yours. In our times, these procedural laws were all taught by practicing lawyers. I had the fortune of being taught CPC and Evidence Act by two leading practitioners of Mysore CM. Of the two, one had very good practice on the civil side, and he taught me the policy procedure. The other gentleman might not have had that much of practice as the lawyer who taught me the civil procedure code, but nonetheless, he too had good practice. That was the advantage for the students who were studying law those days. For reasons beyond your control and beyond the control of your students, that pattern of legal education is a little difficult to us. It's a 5-year law course, a full-time course. Particularly in a city like Bangalore, getting legal practitioners to speak to the students on procedural laws is difficult. And secondly, it is not as if all lawyers are willing to come. They may have good knowledge in the subject, they may have good practice. But teaching, apart from requiring a skill, requires a passion also. You may be a good lawyer, you may be a good draftsman, but you may not be able to communicate with the students. This is the reason why some colleges like you at least frequently invite some lawyers, retired judges to speak to the students, more particularly in this procedural laws. Now there is a recent trend of a faculty development program. Well, every department has it, doctors have it, judges have it. They have the Karnataka Judicial Academy, the National Judicial Academy, Bhopal, where judges are also trained. The reason is law is growing. Every branch of law is growing. So too law is growing. For a judge who works in the court, he is more concerned with the cases before him. He may not have time to get himself updated. If the department has it, there is nothing wrong. In the law faculty also having such a faculty development program. I went through the program schedule. I find I'm totally blissful into the galaxy of good academicians. Fortunately, the subject given to me is not that which requires a good academic learning. But I can only speak from my past experience and present acquaintance in this subject as I speak about it in the Judicial Academy whenever I address the mass. First, I want to tell one thing. The caption which we are reading in the newspapers, WhatsApp messages, social media, that we have new criminal laws from 1/7/2024. While I concede, and I should, that the Bharatiya Sakshya Adhiniyam, which has repealed the Criminal Procedure Code, and the Bharatiya Sakshya, which has repealed the Indian Penal Code, are definitely criminal laws. I cannot subscribe to the view that the Bharatiya Sakshya Adhiniyam, which has repealed the Indian Evidence Act, is an exclusive criminal law. There is some reason for people to link the law of evidence with criminal law. The first reason that comes to my mind is that the book of visions include this Indian Evidence Act in the criminal manual with its two attachments, the Indian Penal Code and the Code of Criminal Procedure. After these three laws put their work on 1/7/2024, they find again the criminal manual incorporating all these three laws. Even before the laws given effective, books were published. So let there be no misconception that the law of evidence is only a criminal law. It is applicable to civil trial as also criminal trial. Yet another reason for linking this only with criminal law is most of the illustrations you find in the Indian Evidence Act and its new avatar, Bharatiya Sakshya Adhiniyam, have illustrations from criminal cases only. That may be another reason. So whatever it be, the Indian Evidence Act, so too the Bharatiya Sakshya Adhiniyam, a good number of provisions which are also applicable to civil cases. They have a very fixed class. It is not that every one of you is teaching the law of evidence in this college. Maybe in a particular semester, one of you will be teaching, another semester will be teaching. Some lecturer has some ill health, some inconvenience, one or two months, he or she may go on leave. Suddenly, they ask you to take up this subject. So, whatever be the subject that you are now asked to teach, be it constitution, property law, whatever it is, better have a basic idea of all the laws, at least to some extent, so that you should be able to manage the scene. Now, we have seen three titles to this. The Bharatiya Sakshya Adhiniyam, Bharatiya Nyaya Samhita, and Bharatiya Sakshya Adhiniyam. Whether the titles should have been taken in English, whether it was appropriate to put them in a different language, I am not on that at all. Those who are writing judgments in Kannada, lawyers who are writing pleadings in Kannada, who are arguing in Kannada, some law publishers, authors have written the Evidence Act. Even before this Bharatiya Sakshya Adhiniyam, even for the Indian Evidence Act of 1872, The Kannada version of it is Bharatiya Sakshya Adhiniyam. Therefore, this 2023 nomenclature as Bharatiya Sakshya Adhiniyam 2023 has not in any way made any change. With regard to the other two titles, any title to any law should reflect its contents. For whatever reason it be, the title given to the other two laws of 2023 does not reflect their contents at all. We have this Bharatiya Samhita. The parliamentary debates and others would show to us that the stress is no more Nyaya, that is Samhita, and not Danda or punishment. If that was the object with which the new law was enacted, there should have been no provision for any kind of a punishment or sentence. You will still find all the sentences which are provided in the Indian Code be continued in the new enactment also. That sentence is also retained. One other new punishment is provided, that is community service. That is provided. Merely, that's also a punishment technically. And therefore, to call this new enactment as Bharatiya Samhita, I don't say may not be appropriate, is not appropriate at all. The Bharatiya Samhita had to be there, no problem. It could still be Bharatiya Danda Samhita 2023. That was the Kannada version for 1860 Indian Penal Code also. Now, with regard to the other enactment, Bharatiya Nagarika Surakshya Samhita, the title is nowhere near the contents. The Code of Criminal Procedure is basically a procedural law. It deals with the procedure to be followed by the police for investigation, correct? Procedure to be followed by the courts for holding a criminal trial. But to call it as Bharatiya Nagarika Surakshya Samhita, or to translate it to English, some Indian law and order, something of that kind. No problem. If you want to have a law for Russia only or safety only, make it. But to call this criminal procedure code as Surakshya Samhita, is it that from 1/7/2024 there are no crimes at all? Everything is safe. Today is already 24th. I think over this 23 to 24 days throughout the country, from 24,000 criminal cases might be registered. It is still a procedural code. Each of these three enactments, as any new special enactment or any amendment act would provide, has a repeal and savings clause. You as law teachers know that the provision is invariably the last of the sections in any enactment. As far as the Bharatiya Samhita is concerned, whether there is that repeal and savings clause or not, Article 20, Clause 1 of the Constitution of India says that you know that the principle being ex post facto laws. If something was not an offense today, and it is made and was not an offense yesterday, and the Parliament of the state legislature makes that act an offense today. And if somebody commits that act, he cannot be held guilty because yesterday when he did that act, it was not an offense for start. Secondly, if X was the punishment provided for that offense yesterday, and if today by an amendment or by a new law, for the same act or the offense, the punishment is X plus something, If the accused is found guilty, he cannot be punished for that X plus. The punishment should be X or something below it. This is the first principle you will find in the first clause of Article 20 of the Constitution. Therefore, to my mind, that repeal and savings clause in Bharatiya Sakshya to put it in the language of law is by way of abolition partial. The Code of Criminal Procedure 1973 also has its provisions called repeal and savings, because the Procedure Code of 1898 was repealed by 1973 Act. That repeal and savings section in 1973, you find a verbatim reproduction of it in Bharatiya Sakshya Adhiniyam of 2023. As law teachers, if you want to do research, you can do about it. But it is of some concern to judges and lawyers. Should we apply the old provisions or new provisions? We need not worry so much about it. It is basically a concern of the public prosecutor, the lawyer practicing the criminal side, and the judge, police also. Well, they have been tried, they are getting tried. Well, each has his own view. About 8 or 10 days back, my son is a lawyer. My daughter-in-law is also a lawyer. My son has another friend, an youngster. My son himself is an youngster. He's a good friend, quite active, though anyone to take quite active. He and myself often interact. About 8 or 10 years back, his friend had called him. He wanted to file a new case, whether he should invoke section 482 CRPC, which says the inherent force of the criminal code, or its corresponding provision with Bharatiya Sakshya Adhiniyam. My son, having corrected the facts, told him that it should be 482 CRPC only. She joined. Appa, what is this conversation going about? I did not hear. I said this. But my son's name is Kaushik. Appa, in this regard, I share the view of Kaushik. I said, no problem. So I lost 3 votes, 2 from my own family and from one from a close friend. Absolutely no issues. A day earlier, one senior district judge called me. Sir, this is my view. What you have got to say. I share that view. The very same day in the afternoon, another district judge from the same place, junior who are in rank and in service, called me for some clarification. I said, this is the position. Sir, our principal district judge also has the same view as us. I said, she is right. Sir, in this case, I said, I have no time here now to have a critical discussion with you. According to the principal district judge is right. She frequently tells me that I thought she might have been hurt by my a little rude way of treating. I sent a message explaining the position. To check this, I got some other gentleman. He said, I am allowing the lawyers to mention both the provisions. Why this confusion? There is one basic principle which you as law teachers should know. Mention of a wrong provision of law in reading or application is no ground to reject that application or deny relief. The only question is whether the court has got power to entertain the matter and grant relief, and the litigant is entitled to it. This is borne in mind. There should be no problem. And subsequently, we have got number of decisions over this 1, 3 or 4 weeks. Delhi High Court has taken the view. Punjab and Haryana High Court has taken the view. Orissa has, Kerala has taken the view. The view taken by the Kerala High Court. Attached to the view I have taken, my daughter-in-law is incidentally from Kerala. I jokingly asked, now that your Kerala High Court has said so, will you change your view? No, I won't change my view. I still stick to my stand. Fine. Say only an intellectual discussion, absolutely no problem. Therefore, law is included. Now, when it comes to this Bharatiya Sakshya Adhiniyam, there is a repeal and saving clause. I will read it because the subject given to me is this. I am not starting from section 1. I am starting from the last section. Only to clarify a particular thing. Because you are not practitioners of law, and therefore to tell your students this is necessary. If you have either by default or design or by choice or chance, a hard copy of the Bharatiya Sakshya Adhiniyam, please take it. If it is available on your cell phone, also I have no problem. Cell phone, tab, laptop, or whatever it is. Or if you are gifted with such a good memory by God that even without looking to it, you are able to comprehend, I have absolutely no issues. I am reading section 117 of the Bharatiya Sakshya Adhiniyam 2023. The Indian Evidence Act is hereby repeated by subsection 2. Notwithstanding, section 3, all of you know that when it starts with the word notwithstanding, it is called a non-obstante clause, NOF non hyphen OBSP non-obstante clause. Notwithstanding section 3, if immediately before the date on which this Adhiniyam comes into force, there is any application, trial, inquiry, investigation, proceeding or appeal pending, then such application, trial, inquiry, investigation, proceeding or appeal shall be dealt with under the provisions of the Indian Evidence Act as in force immediately before such commencement, as if this Adhiniyam had not come into force. My problem is with this. Shall be dealt with under the provisions of the Indian Evidence Act. If instead of this Indian Evidence Act, it had been mentioned as the Code of Criminal Procedure 1973, it would have made sense, but there was no need to do it because the repealing savings clause in the criminal procedure, the Bharatiya Sakshya Adhiniyam would have taken care of. Since you are not practicing as well, no application is filed under the Indian Evidence Act. No trial takes place under the Indian Evidence Act. Trial takes place under the Code of Criminal Procedure. Application is filed under the Code of Criminal Procedure. Inquiry takes place under civil procedure. Investigation takes place under criminal procedure. There is nothing like an application, trial, inquiry, investigation, appeal being filed or continued or tried under the Indian Evidence Act. Whatever is filed under the criminal procedure, whatever inquiry or investigation is made under the criminal procedure, the Evidence Act is applied to arrive at the truth to find out what it is. So therefore, this repeal and savings clause has not correctly dealt with the situation. This may be of some academic interest to you. Now, see this enactment. You might have also seen, maybe you may be able to find a few changes. What I have found is, whatever be the change in the other two enactments, the Bharatiya Sakshya Adhiniyam 2023, the law of evidence, has not brought about any significant change at all in the Indian Evidence Act of 1872. As law teachers and as students, you have learned in the law college, you might have taught in the law college, that the Indian Evidence Act is divided into three parts: relevancy of facts, proof of facts, production and effect of evidence. In the Indian Evidence Act, the first part, starting in the first page, is itself titled as part of relevancy of facts. But the actual sections which are directly dealing with relevancy of facts are to be found in sections 5 to 55. So before the commencement of section 5, the title should have been relevancy of facts. But in the Indian Evidence Act, in the first chapter itself, above that they have mentioned this as part 1, relevancy of facts, where you only find the definition of the word relevant. That's all. All other expressions are defined. Section 2, some deletion, that. 1 as usual, short title, expect commencement. Section 3 is styled as an interpretation class. You have, read number of statutes. Usually, section 2 in any enactment is the definition section. To my knowledge, the Transfer of Property Act and the Indian Evidence Act, they don't style it as a definition, they style it as interpretation. Section 3 of the Indian Evidence Act has the title interpretation. Section 4 has 3 expressions: may pursue, shall pursue, and conclusive proof. Now, this new Adhiniyam has put section 3 of the Indian Evidence Act and also section 4 and section 2. So the entire section 2 is definition section. Then this is one change. So first chapter is only styled as preliminary. Then the chapter relating to relevancy, that first chapter is preliminary and also titled as part 1. What was part 1 under the Indian Evidence Act is now part 2 under Bharatiya Sakshya Adhiniyam with the title relevancy of facts. Part 2 there, proof of facts, is part 3 here. Part 3, production and effect of evidence, there is part 4 here. So whatever be the number given to the parts remain the same. So basically, one part deals with relevancy of facts, the next part, proof of facts, third part, production and effect of evidence. The next change is this. The Indian Evidence Act has given these definitions concept-wise. Fact, fact in issue, relevant fact, document, evidence, proved, disproved, not proved, may pursue, shall pursue, conclusive proof. It is easy for a novice to understand it if it is concept-wise. The Bharatiya Sakshya Adhiniyam has given the definitions in an alphabetical order. Maybe the parliament wanted the definitions to be in alphabetical order for some convenience. Convenience alone cannot always be the criterion. It has to be easy. It is not just convenience for reference, it should be convenience for understanding the concept. Now, what is the effect of putting these definitions in an alphabetical order? Give some unimportant definitions. Straight away, we will go to conclusive proof without knowing what proof means, because it is simple. Without knowing what proof means, we go to disproved D. Without knowing what proof is, because N is prior to P, we go to not proof. Then go to proof. Before that, may presume M. So you can't understand it in any better fashion. Not better fashion, you cannot understand it at all. So those of you who are right now dealing with the law of evidence for some semester, or who are expecting that to be given to you to teach, will kindly bear my suggestion. Tell the students, explain the definitions, concept-wise only, following the earlier pattern the Indian evidence had. Don't go by the alphabetical order given to you, but we are not. This is another change. The Indian Evidence Act 1870 also was amended from time to time. We have this dowry death under 304B of the Indian Penal Code. There is a presumption under the Indian Evidence Act 130 capital B. You must have, I know, small a's, small b's are usually clauses in a section. Capital A's, capital B's, they are independent sections. 304, culpable homicide, not amounting to punishment for culpable homicide, not amounting to murder. 304 capital A, causing death by any rash and negligent act. 304B, dowry death. 498 capital A, cruelty to a married woman. They were all new insertions in the Indian Penal Code. When 498A came to be inserted, dowry death came to be inserted. Some amendments were made to the Indian Evidence Act, providing for certain presumptions. Presumption relating to 498A IPC is to be found in 113 capital A of Indian Evidence Act. 304B dowry death in IPC has a presumption under 113 capital B of the Indian Evidence Act. Then there is a presumption 114 capital A in the Indian Evidence Act says that in a prosecution for rape, if the victim says that she did not give consent to the accused, the court shall presume that she did not give consent, and it is for the accused to rebut that presumption, saying that she had that physical contact with the woman only because she gave consent. This is 114 of the 114 of the Indian Evidence Act. In tune with the Information Technology Act, some amendments were brought to the Indian Evidence Act. 88A, 65B, capital S. Now this Bharatiya Sakshya Adhiniyam has continued in those amendments, has made some more new provisions that capital A's, capital B's, capital C's, they are all removed. They are now given a number. 88A is something like 89. Numbers are given. So the net result is the total sections in the Indian Evidence Act were 167. Now it is 170. 170 is only repeal and savings, not of much consequence. The rest are by and large a reproduction of the earlier thing. Yet another change. If at your leisure you read 165 Indian Evidence Act, you will find that the court is given power to put any question in any forum at any time to a witness, whether relevant or irrelevant. Whether relevant or irrelevant. But then there's a proviso attached to it saying, though the court is empowered to put an irrelevant question, while writing judgment, it shall take into consideration the answer given by the witness only to relevant facts. All of you have heard of the name of Ram J. Kumar. Let's not worry about his political leanings and other things. We are not interested in it. He is an acknowledged criminal lawyer. It was on 27/9/1999, a little less than 25 years back, when there was some additional chief metropolitan magistrate in Bangalore. The Karnataka Judicial Academy was established in August 1999. I was taken as deputy director of the Karnataka Judicial Academy. I got posted as deputy director. And I took charge of the Karnataka Judicial Academy. It was only over in process on 27/9/1999. On the very same day, Ram Jethmalli, even though as a leading criminal lawyer, had come to Bengaluru. The then president of the Karnataka Judicial Academy had instructed the director of the Judicial Academy to get Ram Jethmalli to the academy and speak to the judicial officers who were to be trained. So that was my first day in the Judicial Academy. I had an occasion to hear Ram Jethmalli speaking to the trainers. He gave an explanation for permitting, for even allowing an irrelevant question to be put by the judge. I have not verified whether the explanation that he gave is correct or not, because I have taken it, coming as it did from a person of Ram Jethmalli's learning and stature. I accepted it to be a correct explanation for that. I have not felt it a need to check it. No problem in checking it, but just have accepted it. The explanation he gave was, words are used in a situation where one lawyer says it is relevant, the other lawyer says it is relevant. But as a neutral person, the judge to say whether it is relevant or irrelevant. But words are not used in a situation where a judge puts a question, a lawyer opposes it on the ground that it is irrelevant. Who will decide? It will be a very awkward situation. When a judge is confronted with a lawyer saying that the question is irrelevant, therefore, the legislature thought it better, no question of opposition. But then the legislature did not stop. But regarding evidence, they did thought it should be put. That's relevant and relevant to put it. But while writing judgment, be careful. Don't take into consideration the answers given by the witness for relevant questions. Now, what is the change brought about in Conference 60 to the Bharatiya Sakshya Adhiniyam? Now, no longer the judge can put irrelevant questions. Now, the answers to a question should be only for relevant facts. Then, at your leisure, you may refer to section 11 of the Indian Evidence Act. Facts not otherwise relevant become relevant when they are inconsistent with a factual issue or a relevant fact, or when they, by themselves or in connection with certain other facts, make the existence or non-existence of a factual issue or a relevant fact highly probable or improbable. I believe I have reproduced it from a numerical pattern. It is perhaps in the same form in section 9 of Bharatiya Sakshya Adhiniyam. We have two illustrations to that. One illustration is the principle of alibi. Alibi means being elsewhere. Let us say today at 3:30 p.m. there is an allegation against me that on 24/7/2024 at 3:40 p.m. I committed some offense, drove a vehicle in a rash and negligent manner, or assaulted someone, or killed someone near my house on Mysore port. There is a prudence principle, first principle. Two things cannot occupy the same place at the same time. One thing cannot occupy two places at the same time. So, by 3:40 p.m. I cannot be both at CMR and at near my house. His allegation is that by 5 p.m. it happened. It is quite possible I may reach my house by 5 p.m. Or if the allegation is by 2 p.m. it happened, quite possible. This is what is visibly happening. The illustration given there in the current means some offense said to have been committed by a accused at some place, Calcutta. His plea is that it was in Lahore. That Lahore is now omitted from Chennai, Mumbai, Delhi. So all places like Lahore are not found in the new hand. Places are either Chennai, Kolkata, instead of Calcutta, it is now Kolkata. Instead of Varanasi, it is now Chennai. Instead of Bombay, it is now Mumbai. These are the changes. Then we have provisions in the Indian Evidence Act, which provide for presumption of certain acts of Parliament of the United Kingdom. The reason there was in 1872, we are still under the British regime. It is Britishers, Lord Macaulay, who drafted the enactment. So the reason was some presumption had to be made. The number of provisions to fight Parliament, a law, legislation of the United Kingdom, Parliament of the United Kingdom, Her Majesty, His Majesty, Crown Representative, all these things are now not required. Those provisions have all been removed. This is another change brought about. Now that I incidentally mentioned about Macaulay, it is making it very clear that I am neither for these laws nor against them, because I find not much of a change at all. For me, this change has not made any dent, except for the police, public prosecutors, lawyers practice in the criminal side judges. That too, I dealing with the code of criminal procedure. The other enactments have not made any changes for them to burn their midnight oil and get back. Absolutely nothing. Why I am telling these things? About a week or 10 days back, I just saw a program live now. Leading criminal lawyers in the country, Kapil Sibal, he was angry. Chidambaram, another leading criminal lawyer, was also finance minister, home minister, etc. in his two governments. He was interviewed. A retired Supreme Court judge by name Justice D. Madan Rao was interviewed. A retired judge of one judge of some High Court, a budget committee. Last name is Gupta, Justice Gupta. She was interviewed. Kapil Sibal first asked Chidambaram, because you are the Union Minister, Home Minister, everything. You know how the laws are made, how the laws are passed. What you have got to say about these laws. Forget about the political leaders, I'm not on that. I'm only about his command over the language, the way he uses it. He said it is a posthumous award to Lord Macaulay. What did he say? A posthumous award to Lord Macaulay. Any award given to a person after his death is called a posthumous award. Then he said, you have conceded that you could not have improved upon his language. For me at least, the language of the Indian Evidence Act 1872, the Indian contractor is music and poetry form. The beauty with which the Jawad taught Indian Contract Act already, those definitions, undue influence, fraud, misrepresentation, suggestion as a fact of that which is not true, by one who does not believe it to be true, by one who does not believe it to be true. Misrepresentation, positive assertion in a manner not warranted by the information of the person, making it of that which is not true, though he believes in it. Fraud is said to be fraudulent misrepresentation, whereas misrepresentation as said is said to be innocent misrepresentation. That's the beauty of the structure of Indian contract. You find it in the Indian evidence. Those who have a love for Indian penal would also find it. Well, it's a beautiful language, but there's no issue about it. This is incidental. One important change which you as law teachers should know is this. 133 of the Evidence Act provides that an accomplice shall be a competent witness and a conviction based on his merely because a conviction is based on his uncorroborated testimony, it is not illegal. I repeat, an accomplice is a competent witness and a conviction merely based on his uncorroborated testimony is not illegal. What does that mean? In a given criminal case, even if there is no material evidence, no other material evidence, except that of the accomplice, and the court is convinced about the evidence of the accomplice, we can commit an accused without any other evidence. Corroboration is something supporting evidence. But then, 114 of the Indian Evidence Act says, regard being had to the common course of natural events, human contact, public and private business, the court can presume the existence of the fact. There are a good number of illustrations are given. Without prejudice to the generality of the provisions, the court may presume the following facts. Illustration B 114 says, the court may presume that an accomplice is unworthy of credit unless he is corroborated material particulars. I repeat, the court may presume that an accomplice is unworthy of credit unless he is corroborated material particulars. What is 133? An accomplice is a competent witness and a conviction merely based on his uncorroborated testimony is not illegal. At first blush, you will find an apparent contradiction between the two. I also found it difficult to reconcile them. If you read judgments, more particularly the Supreme Court, you find that there are two things, rule of law and rule of prudence. It is not rule of law, but Daisy has said to the administrative, it is not in that sense. Rule of law means something in accordance with law. 133 of the Evidence Act enacts a rule of law. In law, a judge commits no illegality if he convicts an accused based only on the testimony of an accomplice. That is rule of law. What is the rule of prudence? Prudence means something which a judge should have, some common sense, some discretion. He should exercise it. Now, the rule of law is that a student should come here before 8:30, 7:30, or whatever it is. If he comes by 8:35, suddenly you are justified in law in asking him not to take it inside. But rule of prudence, the lift was not operating. You knew that there is a traffic jam. He knew that the student's father or mother is seriously ill. You know that the student is otherwise ill. Prudence requires that 5 minutes of delay should be liberally used and he be brought in. This is what 114 says. Judge, you are perfectly legal when you convict an accused on the uncorroborated, unsupported testimony of an accomplice. But be a little careful in returning a verdict of guilt based on the sole testimony of the accomplice. After all, who is an accomplice? As the name itself suggests, he is also a participant in the crime. Complicity, accomplice. He is one of the several co-accused. We have a saying in Kannada, ಕಳ್ಳನ್ನ ಕಳ್ಳನಿಂದಾನೆ ಹಿಡಿಬೇಕು, ಮುಳ್ಳನ್ನ ಮುಳ್ಳಿಂದಾನೆ ತೆಗಿಬೇಕು. So one thief can be found only with the aid of another thief. A thorn can be removed by another thorn. That is what a doctor does. He uses forceps. It's also like a thorn to take out a thorn which is fixed or inserted into our palm or soul or whatever it is. In some crimes, the investigating agency finds it extremely difficult to unearth the crime and know who are all involved. Unless one of those involved is given pardon, you please make a disclosure, a true disclosure of what all transpired. Law pardons you. There are provisions. Please read section 306 of the Criminal Procedure Code. I am not able to give you the equivalent of this in VNSS. Very easy. Some comparative table is available in all books. There is what is known as tender of pardon to an accomplice. He is, in layman's language, police language, not an approval. The police take him as an approval. The police make an application to the court to treat him as an approver and pardon him. There are essentially a detailed procedure. You need not worry about it. So, who is that accomplice? To seek pardon from the court, to get exonerated himself of the crime, to see that he is not convicted, he implicates someone saying that it is he who did it. I also did it, but he is also a participant. For good reasons. Unless the law made this provision, it would have been difficult for the investigating agency to unearth the whole crime. Law has made this provision. All right, his says are both well, I am making a true disclosure, everything. But in the heart of his hearts, he will have a feeling, if I make it, I will be exonerated. So it is his evidence, who is also a participant in the crime, that the court is solely relying upon to convict the co-accused, he who has also been accused. Therefore, rule of prudence, which is found in the illustration. Now, what is the amendment brought? 133 of the Indian Evidence Act, if my memory serves me right, which sometimes does, but many times doesn't, is 138. This time it has served. 148 of the Bharatiya Sakshya Adhiniyam. Now there is an amendment to this. How does 133 of the Evidence Act read? An accomplice is a competent witness, and a conviction merely based on his uncorroborated testimony is not illegal. Now 138 says an accomplice is a competent witness, and a conviction based on his corroborated testimony is not illegal. So now 138 of Bharatiya Sakshya Adhiniyam requires corroboration for the evidence of an accomplice, not some other witness, but some independent witness. Now, with this amendment or with this change in new 138, what should have reasonably happened? That illustration 114 we should have been taken off. But you will find that 114 we still as 118 makes no sense. This is one significant change for law practitioners and judges. Now, having said, and as I began telling you, that some of you right now may be teaching the law of evidence in one semester or the other, or maybe the other want to do that. This being a faculty development program, which will add to your existing knowledge. Addition is no waste. Now, there are two definitions in the Indian Evidence Act which are repeated in the Bharatiya Sakshya Adhiniyam also. One important definition is fact. Same thing you find in the, there is no need for me to frequently refer to that Adhiniyam because sections numbers are changed. One simple rule, what is 5 there is 3 here. That's all. Maybe some changes here and there. Now, fact means and includes anything, state of things, relation of things, capable of being perceived by the senses. We have 5 sensory organs. And now we can see 2 of the sensory organs are only ears and eyes. Ears are receiving some sound, but I am not very sure whether ears are perceiving it and taking you to the right place. It happens. Eyes are also receiving. You are seeing me with a blackboard. Some of you may be observing, perceiving, finding that it is not a plain blackboard with some checks and other things. All of you are seeing me with a time. Some of you who may be keen observers, myself forgot it, it's a black thing with some flower-like things. Some of you may be still observers. The shirt which I am wearing now has a similar color as the one that gentleman is wearing. Same color which you are wearing. D, head of the law school, Dr. Subramanian is wearing. So I think I have also observed very carefully. So now, please see that it is perceived, not seen. Perception is at a higher level. It reaches the brain. Everything that we see doesn't get registered. Everything we hear doesn't get registered. I'm confident of what is happening also here, ultimately. So therefore, it doesn't happen always. We can't expect it also. Any witness who comes to the court and gives evidence either in a civil case or a criminal case speaks about a fact which he has seen or which he has heard. They are the 2 primary sensory organs, Panchendriyalu 5. The other 3 are nose, tongue, and skin. Nose very unlikely in a civil case, occasionally in a criminal case. Some foul smell of some dead body lying there. Or if these excise authorities go for a raid to know whether any liquor is manufactured illegally, they get some information saying in a particular village and a particular place, someone is manufacturing liquor without a license. So as and when they go near that place, for 1 kilometer or half a kilometer, that smell emanates. So it is the nose which perceives it. They go there. They are also interested in knowing where it is liquor. They may use the other sensory organ tongue also to check, to test whether it is really that liquor. Now, what is that other sensory organ? Skin. Very, very unlikely in a civil case, but sometimes happen in a criminal case. Somebody is going on the way to his house. Some person stabs him from behind. He didn't see the person stabbing him. It is the skin which perceives it. Then he turns back and sees that this accused is gone. When you travel in a vehicle sleeping, suddenly an accident takes place. You hear a sound or you get a jerk. When you open your eyes, you find it. It happened to me exactly 12 years back, 12 days back. On 12th of 7, 12/7/2024, exactly 12 days back, had got a similar faculty development program to the Christ Law School here in Bangalore. As you are head, she had also sent a vehicle to pick me from my house and give me a drop. So it is 2:30 to 3:30, there it was 12:50 to 1:50. So I was coming in the car back, my home back. I was sitting on the back seat. I was sleeping, I was in deep sleep. The same briefcase which I had brought up with the same set of books. I had kept it on the suitcase by this side. About it, I was sleeping. And I was in good sleep also. About a kilometer away from my house, most of you might have seen the Mysore Road, there is a satellite bus stand there. I heard a big sound. Then I opened my eyes. I found that I had fallen inside the car. Fortunately, not outside. I had fallen down inside the car. Between the seat where I was sitting and the front left seat. My suitcase had fallen down. Something was burnt, some radiator back there, something had burnt. Smoke was emanating. The smell of the smoke was there. It had entered my throat and I was feeling it. I was in a total shock. Something has happened. The driver had already got down. And then realizing some accident must have taken place and developed slight pain in the left leg. Maybe the position in which I was sitting was something, some pain in the neck, shoulder, and other things. I slowly got down to the cart with my suitcase. Then I found people having gathered. The driver said that don't stay here. Then I asked my auto driver, my house is very near. I wanted to gain his sympathy because for that short distance, auto drivers would generally refuse to come. The accident agreement, after rail are continuing, maybe seeing my hair or suit or something, he also okay. Now, why I am telling this is I was sleeping. I didn't see how the accident occurred. It is that jerk. It is that skin. That's through that skin, that sensory organ skin made me feel this. Well, it's a different story. Nothing serious had happened to me except that I had developed. Something serious had happened, I would not have been here today, talking to you without confidence. And I did not want to take a risk because nobody was in the house. I went to a doctor and said, you are walking, your baby is fine, pulse is fine, oxygen, everything is fine, absolutely nothing to worry. Take this pain with us for 2 days, it will be all right, have to be done, it's fine. I'm fully recovered. But I have a different point in this. Now, in this situation, if I am cited as a prosecution witness to speak to this accident, would I be a competent witness? You know the principle in the law of arts, res ipsa loquitur. Things speak for themselves. It's a different matter that some courts have taken the view that is a principle which has emerged from the law of arts, basically a civil law. It may not be appropriate to apply the principle in a criminal case when you hold the accused guilty of a negligent act. Some courts have said when there is more than believable evidence, it may not be wrong for the court to involve the principle of res ipsa loquitur. Whatever it is, let us take it that it applies. I repeatedly told you, I had closed my eyes. I really do not know whether the driver of the vehicle in which I was going was at fault or somebody was at fault. Those of you who have seen that Mysore road would know near that satellite bus stand there is a road divider. My vehicle was going in the direction towards Mysore. It is where my house is on the left side. It is unlikely that a vehicle from the opposite direction would have hit this vehicle because there is a road divider. Right. Unless. Then what's the possibility? The driver of the vehicle in which I was going must have dashed or hit another vehicle which was going in front of it, or he might have hit a vehicle which had been parked on the left side. Now, if we had hit a vehicle which had been parked on the left side, which portion of the front portion, which side of the front portion of the car should have been damaged? The left portion. What I found was the middle portion having been seriously damaged. I had not opened my eyes. Who was the best person to speak to that accident? Driver would be accused in that case. Constitution protects him from making any self-incriminating statement. It is open to him to enter the witness box if he wants. Police in the normal course, I really do not know that the police registered a case. So far, nobody had called me. Who was there? There was a retired district judge. Well, he was the best witness to speak. Of what use my statement? I would honestly explain. Fortunately for me, the 161 CRPC, if you find as someone 63 or 144, says that no police statement shall be signed. I was telling my friends, the Judicial Academy, let the court treat me hostile. I would say I really did not know anything how it happened. I was honestly sleeping when I woke up this hat. I heard I saw it. But then, can my evidence be totally ignored? I was the best person because I was sitting in the car. These things speak for themselves. Right? The fact that I had fallen down inside the car, that the same briefcase which I had brought, which I was carrying on that day, had also fallen. Then the middle portion of that front portion of the car had been damaged. There being a road divider, probably I did not notice whether there was any vehicle parked on the left side which had also got damaged. The only inference that can be drawn in the circumstances is that the driver of the vehicle in which I was going, must have driven it in a negligent manner, and he must have hit a vehicle which was going in front of it. So I just am only incidental telling it because it happened just exactly 12 days back. Nothing has happened to me, otherwise I would not have been here before you to speak to this purpose. Now the same thing, whatever is perceived through these senses, would be a relevant fact or would be a fact to depose in a civil case also. Give you an example for a criminal case. Maybe any other criminal case, somebody is cultivating his land, another person comes, stabs him. A neighboring landholder, he hears the screams, goes there. He finds that this accused of stabbing him. So one sensory organ, ear has heard him screaming. Another sensory organ, eyes have seen the accused stabbing this man. By leaving the place, the accused says, today this man has come to your rescue. Otherwise, I would have killed you. All offences under the Indian Penal Code, trespass into the land 447, wrongful restraint 341, stabbing by a knife 324, criminal intimidation 506. These things would happen. In a civil case, execution of a document is impossible. Somebody says, I was thought to be present as an attesting witness. He called me, I went to them. He called me, yes. I went there, I found all these persons present there. Yes, eyes. He signed this document, I signed, I identified signature, eyes. So these are facts which are there. Now, there is a factive issue, a very complicated definition. I'll just make it simple. You must have seen all 14 CDs. After the readings are complete, the next stage is, of course, the no CPC requires that the matter should be referred for some kind of an alternate dispute resolution. under section 18 assuming that it is done or not done, the usual state is to frame issues based on the pleadings. Now, from the pleadings, the court would say who has to prove a particular fact. Plaintiff says that he has lent money to the defendant, defendant denies it. First principle, the plaintiff has to establish that he lent the money. The issues are in an intrajudicial sentence form, whether the plaintiff proves, does the plaintiff prove or other thing. Now, it is the Indian Evidence Act 102 to 104, corresponding provisions from 103 to 107 of the Bharatiya Sakshya Adhiniyam, which tells us on whom the burden should be cast. There are the plain. So now it is the same Evidence Act, the same Bharatiya Sakshya Adhiniyam, which we make use of to hold a trial, a civil trial or a criminal trial. That's why I started telling you that merely because it is called a new criminal law, these publishers have included the evidence law in a criminal matter. It is not an exclusive criminal law at all. It applies to a civil trial and to a criminal trial also. Now, these facts, which are the facts in dispute, are technically called facts in issue. In a civil case, based on the pleadings, that is order 7 blind or 8 can state, issues are framed under order 14. In a criminal case, these issues we call charge. Prosecution is called upon to do the charge. In a civil case, the plaintiff or the defendant is called upon to prove issues. This fact in issue which you find in the Indian Evidence Act in Bharatiya Sakshya Adhiniyam is an issue that the judge frames in a civil suit under Article 14 and the charge that he frames in a criminal trial under the relevant provisions. Fact and fact in issue. Now there is the definition of a relevant fact. What is a relevant? Any fact is required to prove a relevant fact. You see any commentary in the Indian Evidence Act, you find two expressions. Facta provenda and facta provenda. One thing is a fact in issue, what is required to be proved. The other thing, a fact that is required to prove it. You see, plaintiff has lent money. Defendant says that he has not borrowed money. It is not sufficient if the plaintiff says I have lent money. That's a fact in issue. How to prove it? Now, let us say, today there is some absolutely no problem. Let us say there is some program. We have started a meeting at 5:30 p.m. High Court. I tell the registrar of the High Court, no, I am in CMR University. I can't come there. No, my information is that you are not up to CMR at all. Absolutely no dispute. I am just telling you, only to make no mistake. Now, I in the High Court are at issue. I am making a positive assertion that I am at CMR and therefore I am unable to come there. High Court says we are deliberately missing the meeting. Who is the best person to give that evidence? Bharatiya Subramaniam, because I had invited him because here I was very much presented. After all, I make a self-assertion saying that I had gone there. It is not as if an employee where he will, like a last attendance certificate from him. I can only request him and use his good speaking moral evidence on my behalf. That evidence which Dr. D.R. Subramanian used is my support to say that on invitation he had come with us. It is quite unlikely that he could have waited the High Court by 5:30. This additional evidence, this additional fact to prove the issue between me and the High Court, whether I deliberately missed the meeting or could not attend the meeting because of my commitment here. To resolve that issue, to resolve the dispute, some additional fact, facta provenda and facta. So this additional fact is called a relevant fact. You will find in the Indian Evidence Act section 5, corresponding provision is 3 here. See the beauty of the Indian Evidence Act. Facts which are hereby declared relevant and no others. In every suit or proceeding, the court shall receive evidence of facts which are hereby declared relevant and of others. The beauty of that section 5 of the Indian Evidence Act, in the beginning I said, there is the poetry of Indian language, the Indian Evidence Act, and the Indian Contract. As I said, Chidambaram said, we would not have improved upon his language. It's a posthumous award to all began. So there are two aspects here. One is in a declaratory form saying, well, the evidence that I have declared, these are the relevant facts which the judge has to bring on data to prove a factual issue in a civil case. To prove a charge in a case. I don't stop there. I am so emphatic. It is not that merely have declared these facts as relevant. I further prohibit the court, Indian the court, from receiving any additional facts. Hereinafter declared as relevant and of interest. We have heard of a saying, be you ever so high, now is above you. A gentleman thinks that you are very intelligent, you are very learned, therefore authority it is relevant. You are a very leading lawyer, or a very popular lawyer, you think that you are very intelligent, therefore every question it is relevant. Evidence Act says, however learned you are, I am above you, I am law. I have declared by this act that only these facts are relevant. Which are those facts which are declared as relevant and speak in this fact? They have been removed from 55 and it's corresponding to the sections. Here are what is 5 to 55 there? Here it is 3 to 50. One with two numbers we just subtract with it. The first group of those relevant facts, all of you are familiar with this expression, the rest just wait. Facts connect with each other. Section 6 of the Evidence Act, which you find in section 4 here. Facts door on an issue are so connected that fact in issue as to form part of the same transaction. A simple case. On 24/7/2024, at 4 p.m., something happened in CMR. It's a charge on issue. Right. To do this, it is not just sufficient. If I say that I had gone to CMR by about 1:30, had lunch, Professor Ishwar was but certain additional facts have to be placed. If it is seriously in dispute, it doesn't matter reach the court only when the parties are at dispute. Now, what are those relevant facts, additional facts to prove this small thing? That there is a faculty development program. Dr. T.R. Subramaniam, who had seen me in the Judicial Academy, had called me early. He thought that I could be of some relevance here also. And therefore, a week back, they had gone. He was kind enough to see that the vehicle was not, everything was taken there. Who is a faculty development program at CMR relevant? No. It is relevant to establish the fact that I was here on that day and something happened on it. The issue is not whether there is a faculty development program in CMR from 22nd to 29th. The issue is whether on 24/7/2024, something happened here for me or for Dr. Subramaniam or somebody else. To prove this fact issue, some related things, they form part of the same transaction. In number of civil cases, the defendant who is the owner of the property agrees to sell his property to the plaintiff. He doesn't sell it. We have in the specific legal right a remedy called relief card specific for farms. The plaintiff files a suit, he agreed to sell the property, did not grant me a specific terms. The usual defense of the defendant these days is it was not a sale transaction. I never intended to sell my property because this was the only house I had. My maternal grandfather had gifted this to me. But I have got a sentimental value. I thought really never intended. Plaintiff is a professional money lender. He lends money for interest. His practice is he just does not accept a promissory note or a check or some loan document whenever loan is lent. He insists on the debtor, that is the borrower, to execute a document in the nature of an agreement of sale as a security for the loan. Though this document reads like an agreement of sale, it in fact represents a loan transaction with a security part. This is a popular difference that is taken. It is not enough for the plaintiff to say that he agreed to sell, not enough for the defendant to say that it is only a loan transaction. There may be several other circumstances, there may be several other facts. Plaintiff may say, well, I wanted to buy a land or I wanted to buy a house. I had asked some villagers to find out if any house or land is available. Somebody said that this defendant was willing to sell him. I approached him, we negotiated. All these things are part of the same transaction. Transaction does not necessarily mean paying some money and getting some goods. It both means. Then we have that then another set of admissions and confessions. I will only give you some two decisions which you as law teachers will please take time to read. They are old decisions, I know, but they tell you the basics. See, we have what is known as a confession in the Indian evidence. There are three kinds of confessions. Confession to a police is totally part of section 24. It is no confession at all in the AF law. See, what these newspapers will do is accused confessed, TV predictive. Whether it confesses before the police or not, law doesn't take it at all. That is 24 the evidence act. Then we have a judicial confession. That is during the course of investigation. If the accused wants to confess, he can't confess it before the police because it is no confession. Courts do not recognize it. Law does not. He is taken to a judicial magistrate. It is not evidence that it says how that is to be regarded. It is the code of criminal procedure 164 CRPC. It's not warranted from 182 or 183. That confession is regarded by a judicial magistrate and therefore it is not a judicial confession. In the law, judicial confession can be the sole piece of evidence without any corroboration to the evidence. Police confession is no confession. This is a perfectly legal valid confession. The third kind of confession is extrajudicial. Let us be too honest. Each one of us have one point of time or the other. May not be a crime, we have committed some mistake. You would have told our mothers today we are suffering from headache, we are not able to go to the school. Something of that kind. Later we feel bad, we feel kind of repentance. Amma, I should not have, I really could not have it, I did not want to do it. Or we may tell our friends. So we confess a mistake with a close friend of ours, wife, friend, mother, teacher, whoever it is. With a hope or assurance that he would not disclose it to others. But in reality, it doesn't happen. So if the accused confesses the guilt, not before the police, it is no confession. Not before a judge, but he confesses it in a person of his confidence. It is called extrajudicial confession. It is a perfectly admissible piece of evidence. Now, the full law regarding evidence, we can also relate it to Article 20, Class 3, right against self-incrimination. Therefore, even if the accused makes a long statement saying that he himself stole the property, he committed rape on a woman, he killed somebody, it is no confession. But it's an entire statement. If there is something which has some bearing on the facts, That portion is called exculpatory, culpable mental state. He is a culprit. That means some person who has committed. There are generic words, culprit, culpable mental state. So now, exculpatory, in a statement where there is some facts which do not implicate the accused, which do not point out to the guilt of the accused, they are called exculpatory statements. On the other hand, if some part of it interprets the accused, makes him self-interpreting, that is called interpretatory statement. We have a very beautiful decision of the Supreme Court at this point, which you as faculty members will please go through this. There are good number, but this lays to the foundation. AR 1966 Supreme Court 119. AR 1966 Supreme Court 119. Arjunu Nageshaya. AGHNO. Arjunu Nageshaya versus State of Bihar. Exculpatory and inculpatory statements. A very beautiful analysis. An FIR is taken. First sentence, Supreme Court says it is exculpatory. It does not implicate the accused in any way. Next sentence, it implicates. A very beautiful analysis has been made. Then, having said this, confession before a police is no confession at all. There is some exception to this. You have, I don't know. An exception is either the form of a particular exception itself, exception or exception to like this. Sometimes it is by way of proviso. The section which provided. So we call it as provision. Though some persons may call it provision, it's not provision, it's a provision, it's an exception. Proviso is always attached to the main section. But the Indian Evidence Act makes an exception to this general scheme also. Section 27 of the Indian Evidence Act, which you find in section 24 of the Bharatiya Sakshya Adhiniyam. 27 of the Indian Evidence Act is an exception to the earlier section 26. It should have been an exception, but it is given an independent section. It reads, provided that if any fact is supposed to as discovered pursuant to an information furnished by the accused in the custody of a police, so much of such information as relates distinctly to the fact thereby discovered, some fact relating to the crime, which was not known to the police before the accused made it, becomes a discovery. What's a discovery? Something which we for the first time come to. It is through the accused only for the first time the police come to know it. To that extent, confession to a police, if there is something in it which enables the police to discover a fact, is perfectly relevant, perfectly admissible evidence. We have a very beautiful decision of the Privy Council, which has been followed by the Supreme Court even to this day. Please begin your learning with that and end that also with the same, because there is nothing more about the decision. AR 1947 Privy Council, page 67. AR 1947 Privy Council, page 67. Pulupuri Kottaya, some person from Andhra. Pulupuri Kottaya versus Emperor. It's a Privy Council decision. In fact, you will be knowing if a decision has stood the test of time, it is called a locus classicus. LOCUS, locus classicus. CLASSICUS. 1947 Privy Council decision. Even in the year 2024, Supreme Court is followed. But somewhere in 2000 or 2002, the Bombay High Court made a departure. Justice K.T. Thomas, a judge of the Kerala High Court, who later became a judge of the Supreme Court, a very learned judge. The very first sentence he wrote in that judgment against the Bombay High Court judgment, which the Supreme Court was, the Bombay High Court unwittingly has chosen to deviate from Pulpuri Kottaya, a lotus classicus. That means Supreme Court has considered it as a lotus classicus. Please read it. Then we have one decision regarding date declaration. What is this concept regarding date declaration? We have a Latin expression, nemo maritaris, N-E-M-O, nemo maritaris, M-O-R-I-T-U-R-U-S, M-O-R-I-T-U-R-U-S, nemo maritaris, presumptor, P-R-O-E. So this Roman Latin, the pronunciation and spelling will not be in accordance with English. P-R-O-E-S-M-U-M-I-T-U-R, presumptor, mentiri, M-E-N-A-R. The English translation of it is, a man will not meet his maker, M capital. Capital maker means God, will not meet his maker with a light. It is the Indians who are accused of all these superstitious beliefs. Even they have that belief, saying, well, they believe that a man who is on his deathbed is unlikely to lie because he does not want to keep a lie in his mouth and meet his maker. Therefore, he has nothing to lose, no hopes. Therefore, law presumes that he makes a true disclosure. The leading decision on this very declaration is AR 1958 Supreme Court, page 22. As law teachers, particularly those who may teach the law of evidence or Bharatiya Sakshya Adhiniyam, please read these 2 or 3 decisions. You will learn for yourself and you will lay a good foundation for your students. AR 1958 Supreme Court, page 22. Vishal Rao versus State of Power. I think that this should be sufficient for today because it's 1 hour. And if you have got any questions, because there is good lot to tell. In 1 hour session, the whole subject cannot be very good. So take it from me with an amount of confidence, which I believe all of you have, though you are new to me, that the Bharatiya Sakshya Adhiniyam for 2023 has not brought about any significant change. Unlike the other 2 enactments, whose titles do not really reflect the content, the Bharatiya Sakshya Adhiniyam really reflects its subjects. It's a correct translation of the Indian Evidence Act also. As I said in the beginning, those who write judgment in Kannada use that expression only, Bharatiya Sakshya Adhiniyam 1870. No serious changes or substantial amendments and changes. From the 3 or 4 changes, particularly with regard to the evidence of the accomplice witness, and the court were only to put relevant questions, not irrelevant. Barring that, there is no change. Here and there, some change sections are read. In tune with the Information Technology Act, there is one serious issue about which I request Dr. T.R. Subramanian to get some lawyer or some expert who can speak on digital ethics, both for the faculty members and for students, because good number of changes are brought. Maybe for the law teachers as such, it may not be a big problem. But for law practitioners, judges, and police, it is really likely to cause some problem. Because the way reading of those sections would indicate that every time an electronic record is produced to the court, that the Indian Evidence Act and the Bharatiya Sakshya Adhiniyam are contemplated certificate, saying that the computer system, the computer was in the possession of the person from whose system it has generated, and it was in a working condition. He was using it in the regular course. The new Adhiniyama also provides for it, and format is also given. The additional thing is not only a certificate for the person in whose control or custody the computer or any electronic device is, an additional certificate from the expert. Who that expert it is dependent in the Information Technology Act. I think that may have a serious problem for the litigants Every time you want to produce an electronic record, get a certificate from the expert also. To speak to it, you need an expert. And I confess I cannot be adequate to answer any questions which the participants might ask. My request to you is, at your leisure, we can get some good lawyer dealing with digital evidence or some judges. In fact, CM Joshi, Justice CM Joshi had come here, you had told me that he is a student in something. Yes, yes, CM Joshi is a judge here. Yes, yes, I think he was your student also. I think he had also the once you had told me. He is quite good. He is quite good.
Setting the section.
Yes, yes, computer section. He is quite good. We can get him. We have a lawyer by the name of Deshpande. Deshpande, a leading lawyer both on the civil and criminal side. Recently, he also gave 2 or 3 lectures on academics about this digital evidence. We have a police officer by name Yashwant Kumar. Yashwant Kumar. Maybe, I don't know whether a police officer is permission from the department to come here. He goes to the police department and other institutions, public bodies. You just ask a very simple man who can communicate effectively. This basically is an MTech. He was teaching engineering students in Tiptur Engineering College. Yes, he was an MTech. Then he had taken up this examination from police service because of his technological background. He is now in this cyber crime police station investigation of these cases. He is also quite good.
Recently.
Cases.
Yeah.
So I think that you can ask him to speak. Yes, any questions? Any questions? I find from the time schedule, a leading lawyer from Chennai by name Shri Chandru is coming. He gave some 2 or 3 lectures in the Judicial Academy. Very recently, last Sunday, today is Wednesday. Sunday or some day, 2 or 3 days back. He had come to the academy to speak to the High Court judges also. He also went to the courts and other things. You can use citations, but I'm not sure whether one will is sufficient for it, whatever it is. Well, it can keep you lively also. Very lovely fact. You can go on citing decisions wait continuously for 3 to 4 hours. That is his staff and capacity also. Professor has chosen a good resource person. If you have got any questions from my side, not necessarily confined to Bharatiya Sakshya Adhiniyam, can we have some help you, even with regard to some conventional civil law survey. Constitution or professor is here with us. If there is anything connected with the trial judiciary, any procedure regarding it, I'll be happy to see you. Thank you, sir, for the great opportunity given to me. I'm honored by an invitation from a professor of his stature, heading a law school, which is part of a university by itself. This university has made a name in the city. He himself has that name as a good academician. His elder brother was practicing before as a lawyer in Medicare. So, he casually told me that his brother is heading the Karnataka Law University. I met him about 2 years back in our judicial academy. So, about 6 months back, he has come. Thank you, sir.
Thank you so much, sir. Thank you so much for your valuable insight on Bharatiya Sakshya Adhiniyam 2023. It was indeed a very engaging session.